All right, next up, we have some updates in United States v. Comey. First, and this is from a few days ago, the defense's motion to dismiss based on unlawful appointment of Lindsay Halligan is going to be handled by South Carolina District Judge Cameron McGowan Curry, who is pretty, I think he's in his 70s. And he's also going to be handling the motion to dismiss based on unlawful appointment that Letitia James filed in the Eastern District of Virginia in her case. And because they're both dealing with the appointment, I think he's going to get both of those. And we'll see what happens with them. I actually think that they have a pretty strong chance because I don't really see how Lindsay Halligan's appointment is lawful. I don't think it's lawful, but that doesn't mean that these cases are pointless. I think I'll get to why I don't think they're pointless here in a minute. But he's going to handle it, and it's going to be in early November. It's when the hearing, I believe it's on the same day. I want to say it's November 13th, maybe, is the day that he's going to have a in-person hearing for both James Comey and Letitia James. Not positive on that, but I know it's in early November. And for those, and right here, as you can see, this judge was appointed way back March 11th, 1994, by then President Bill Clinton. So happy Re-Day for all of those who celebrate. Now, more interestingly, there's been a new filing over the weekend or on Monday sometime. Not really sure because everything on Pacer is delayed because of the Pacer hack and all the fallout from it. F you, Russia, and F you, all of these groups who have been hacking Pacer. God, it's frustrating. United States v. Comey. As expected, defense has filed an opposition to using a filter team for Arctic Haze evidence that was seized years ago from Daniel Richman, who was then counsel to James Comey and is now person 3 from the indictment against James Comey. The defense team wants to first challenge the underlying search warrants used to get that evidence, which we've talked about in a previous episode covering updates in Comey's case. And that evidence appears to be communications between Comey and Richman. To do that, they need prosecutors to turn over what we now know were 4 search warrants that were used in Arctic Haze to go after these communications. Defense's filings in this, they give us some insight into the Arctic Haze investigation, and in my opinion, they foreshadow what this case is really about, which is sealed material and getting it unsealed. That's why I say these cases, even though I think they're gonna, I don't know about Letitia James, but I think Comey's case is going to fall apart. And in some sense, I think of the motion to dismiss for unlawful appointment. I think of it as the kill switch. It's a built-in kill switch to this case. And I think it was intentionally put there. Like all maybe not like all kill switches. It depends on the engineer, right? Some kill switches are not intentional. All right. So here's their opposition. I'm just going to take you through it, my thread on it anyway. I'm not going to take you through the whole filing. A filter team is needed for a set of evidence, okay, that was seized per search warrants on one of Comey's attorneys, Daniel Richman, who's person 3 in the indictment. And it all stems from the Arctic Haze investigation. And the Arctic Haze investigation was one of several media leak investigations. Thank you for this chart, Cody. Cody put this together a while back. And I love it because it ties together all of them with their dates and what they were about and who the journalists they targeted were. There was Arctic Haze, Echo's Fate, Foggy Falls, Genetic Christmas. The Schiff whistleblower is thrown in there, although that wasn't. Yeah, it's a media leak investigation. Riding Hood, Siren's Lure, and Tropic Vortex. These were all media leak investigations, many of which started while Comey was still director of the FBI. Some of them started after he was gone. Arctic Haze is the one we're concerned about. Arctic Haze is the one that went after whoever gave classified information to the New York Times for this article. Comey tried to shield the FBI from politics, then he shaped an election. In this article, Daniel Richman is quoted. He is named as a source for much of what's in the article. The classified information that appears in this article relates to the Renteria memo and the Russian reports. Remember, the Durham classified annex was declassified this summer, and we learned a lot about those Russian reports. There's a section in this article that deals with them, and it talks about a document obtained by the FBI reinforced the idea in Comey's mind that DOJ was not interested in prosecuting a case against Hillary Clinton. And this memo that's at issue here and an email was written by Amanda Renteria, which says or assures a person from the Soros Society, the Open Society Foundation, I should say, Bernardo, who was hacked by the Russians, that AG Lynch isn't going to let the investigation into Secretary Clinton go too far. Remember that? The seized material in the Arctic Haze investigation is quarantined at this time, meaning neither the prosecution or the defense can look at it, or they're not supposed to. A filter team would be used to screen that evidence for material that may be potentially attorney-client privileged, which all or most of it is going to be privileged, or initially it's going to be claimed to be privileged because it's communications between Comey and his lawyer, who is person 3 in the indictment in this case, Daniel Richman. Now, this is one of my favorite parts of the whole filing. It says, the government has no lawful basis to review material obtained more than 5 years ago in a closed investigation, meaning Arctic Haze, that ended without any charges pursuant to stale warrants for separate offenses, including materials that remain under seal by another court. Folks, I believe we call this foreshadowing in the biz, because why are they bringing that up? Why are they bringing that up? As part of the Arctic Haze investigation, Comey provided his iPhone to the FBI. On it were 4 voicemail messages, 4 instant messages, 2 email messages, and 51 images from December 1st, 2016 to May 1st, 2017. But according to the Arctic investigation memos, none of that material contained information relevant to the Arctic Haze investigation. I wonder if it was relevant to any other investigation or will be. If it will become relevant to an investigation. They took other investigative steps in Arctic Haze. They searched all the FBI hardline phone. Remember, they're looking for a leaker. They searched all FBI hardline phone and email records for contacts with known reporter facilities, also known as spin searches. They reviewed those spin searches. They obtained and reviewed a multitude of telephone records on FBI cellular and work phones for FBI employees in the subject pool, including text messages. They took 3 redacted steps that we don't know what they are. They analyzed handwritten notes taken by FBI employees. They analyzed thousands of documents and other items of evidence, redacted. Reviewed administrative and classified materials, redacted. Reviewed 3 reports issued by the U.S. DOJ OIG. Reviewed FBI 302s of DOJ and FBI witnesses provided by the Office of Special Counsel Mueller. Reviewed a 2017 investigation conducted by John Durham, which was Tropic Vortex. Interviewed numerous current and former FBI, DOJ, and U.S. intelligence community employees who had access to the classified information that leaked in that New York Times article. And then they took 2 more redacted steps that we don't know about. Arctic Haze went through all of that and charged nobody. In fact, they concluded that based on everything we've gathered, there's no more investigative leads to follow, and there's not enough evidence to charge either Richman or Comey or anyone else with leaking classified information to the New York Times, or with any crime, actually is what it said, with any crime. Back to Comey's new filing. Defense wants the government's motion for a filter team denied. But they want it denied without prejudice. They don't oppose the filter team protocol. They oppose implementing it before the government identifies a valid legal basis for its search and fully discloses the scope of the materials it seeks to review. So, that's consistent with what they said about 2 weeks ago in a different filing. It's also consistent with what they told prosecution when prosecution approached them about the motion for a filter team. We learn in this filing that Arctic Haze had 4 warrants, but we don't learn much about them. It tells us that they exist. It describes them, but it's all redacted in this new filing, and it's redacted out of an abundance of caution because, remember, there's a protective order on the discovery, and they're not allowed to share what's in discovery with the public or, with anybody outside the case. They're precautionary. Now, they might get lifted, and defense makes sure to include in a footnote here that they see no reason why the information about the warrants cannot be made public, which tells me it's pretty obvious that they were for Daniel Richman's phone, his computer, maybe hard drives, email accounts, those things. Things you can pretty reasonably deduce they would be for. The search warrants appear to be against Richman, of course, person 3, and covered from 2016 to 2019. That's how I read these sentences here, although there's a redacted sentence here at the end of it. But this is 3 years prior to Comey testifying. So it's a bit weird to me that this is where that these warrants covered that time period. A filter team previously went through the material, and Richman was involved, given the opportunity to assert privilege, but Comey was not part of that. There's a short sentence here that's redacted, and I wonder what it says. I'm thinking it may say something about Mr. Fitzgerald not being involved, who's Comey's current counsel. But I'm not positive, and I don't know why that would be redacted. It says, Mr. Richman is an attorney who represented Mr. Comey beginning in May 2017, in addition to other clients, period. Very short sentence, period. Then Mr. Richman also had sensitive and private materials belonging to his students within the seized materials. Maybe it says Mr. Richman served as a special government employee, but I think that's already public. It's already public, but I think it's already public in one of the filings. I'm not sure. Another thing that's really interesting in the filing. It is unclear whether the government intends to search only the materials marked responsive by the U.S. Attorney for the District of D.C., that team that the Arctic Haze warrants came from and that authorized them to seize, or if the government intends to review both responsive and non-responsive materials from Arctic Haze warrants, i.e. the full raw returns. The government declined to answer the defense request for more information on this. So is there something specific in these search warrants and that material that they want to look at? Or are they just wanting to look at everything and hoping to find something? Prosecutors haven't obtained search warrants in connection with this case, this current case. And they haven't sought authorization for a search of the Arctic Haze materials for evidence of the 2 offenses with which Mr. Comey is charged. Like, why didn't they do this before? When Mr. Comey fell under investigation this summer for the offenses that are charged here, why didn't the government seek court authorization to look at the Arctic materials then? Why are they now going after them? See, this is another reason why my working theory regarding this case against James Comey is that it is not about getting James Comey. It's about getting at classified and sealed materials. I think it's about the 1A package and the Durham memo that are from the Tropic Haze investigation, which all of these leak investigations are connected, which is strange. We got one person charged here, Comey, but all the leak investigations are connected. The stuff that is behind the redaction blocks in the declassified memos from this summer, I think, is also what this case is about. And I think it's about another case, possibly the case that we recently learned is being built in Florida, in which there's 2 grand juries that have been impaneled for. And those 2 grand juries were impaneled, or the order, should say, the order to impanel 2 grand juries in the Southern District of Florida came down a day after the Comey indictment did. Comey was indicted on September 25th. These 2 grand juries were ordered to be impaneled this coming January on September 26th. So now that doesn't necessarily mean they're connected, but I think they are. I think this is the rumored. I'm kind of jumping ahead to a different topic I was going to talk about on the show, but whatever. There's been rumors going around that there's a grand conspiracy case being put together in Florida. And it's in Florida because that's where Trump's residence was, or is. And the conspiracy, the grand conspiracy, is because there was a grand conspiracy against Trump to deprive him of his rights and deprive all of us of our rights, in that we elected Trump in 2016, and there were individuals who sought to undermine his campaign, corruptly undermine it, and to corruptly undermine his first presidency. And that grand conspiracy continued throughout his first presidency, continued through the Biden administration, and there are many players in it. You know the suspects. And so it's a conspiracy against rights case, 18 USC 241, which is the same charge they brought against Trump in the J6 election case. Now, defense counsel thinks there may have been an oopsie here in the handling of this quarantined evidence from Arctic Haze. They believe that lead case agents got a look at some of the things that's in that evidence that they shouldn't have gotten a look at. They don't go into detail. Well, publicly, they don't tell us. But if you look right here, they got this privilege spill, which this is another thing that could make this case fall apart. But it's redacted, so we don't know everything that's here. But they say that materials produced in discovery confirm that lead case agents, redacted, may have been exposed to attorney-client privilege materials belonging to Mr. Comey. That would be a big uh-oh. The next part of the filing concisely restates the filter protocol and what it would be, and advises the defense that the defense stands ready to confer regarding the protocol if prosecutors will first identify to the defense the materials to be reviewed. Which they haven't. And it kind of at this point looks like a fishing expedition. Why, like I asked earlier, why wasn't this filter team done before they indicted Comey? They could have done that. They could have gotten court authorization to unseal. They could have, or at least asked for it. They could have asked a court to bring about a filter team. And they could have gone to Comey before he was indicted and said, hey, we want to look at this stuff. We're going to use a filter team, and you're going to get the opportunity to assert privilege over these attorney-client communications. And they could have had this battle over this evidence before indicting Comey, but they chose not to. Right now, it looks like an investigation post-indictment using material from more than 5 years ago. And that material failed to find any evidence of a crime to charge Comey or Richman with. So why do they want to look at it now? And that's really like, that's like, it's see how I hope that hits like how strange this is. There's this old investigation from over 5 years ago into Comey and Richman for media leaks. A bunch of different investigators looked at it. It was connected to all these other media leak investigations that went on for years and years trying to figure out how stuff within the FBI was leaking out to the press. And the people who investigated Arctic Haze, they concluded there's nothing here to charge Comey or Richman with. And Comey provided his iPhone. The FBI phone lines were looked at. Cell phones were looked at. All these things. They didn't find any evidence to charge either of these guys with a crime. But then, now that Comey has been indicted, years later, allegedly for false statements to Congress about this same subject matter of leaking to the press, they want to go and look at this evidence that was gathered pursuant to these 4 search warrants, even though the investigators from back then, 5 years ago, concluded that it didn't evidence any crimes committed by Richman, person 3 in the indictment, or Comey, the defendant. Defense says the government is seeking to revive and repurpose years-old warrants from a closed investigation to conduct new searches for different crimes. We can parse that, and that different crimes part really catches my eye. Now, Comey's team, let's say this plays out, which I think it will. This is going to happen. I don't think this is going to get shut. I don't think this is going to get shut down. I think there's going to be a filter team, and they're going to look at this quarantined evidence, and Comey's going to assert privilege over some of it. And at some point, we may see a move to suppress this evidence. But I do think we're going to go down this road. And I think we're supposed to. I think that's the reason why Comey was indicted. To generate a legal cause, to go after this court-sealed material. Because I think it's for different crimes. The Arctic Haze warrants, I almost said the warrants. The Arctic Haze warrants, by their express terms, do not authorize the government to conduct the searches it now seeks. Now, that's kind of strange, I think. The Arctic Haze warrants targeted only alleged violations of redacted. The government now proposes to use those warrants to search for evidence of different crimes that arose from a proceeding that occurred after those warrants were obtained. The Fourth Amendment forbids this expansion without a cause. The Arctic Haze warrant sought increasingly granular details or attempted to address potential gaps in the collection, yet the government ultimately determined that the evidence was insufficient to proceed with any charges. Again, defense wants to challenge the warrants first and then go on to dealing with the protocol. The court, they argue, should deny the government's motion to implement its proposed filter protocol without prejudice and direct the government to disclose the following information. Only with these disclosures can the court determine the legal validity of the proposed searches and assess any proposed filter process. 1, they want the legal authority for the contemplated review. What is the legal authority that allows for this review of that evidence to occur? 2, whether any quarantine materials have been accessed by, shared with, or provided to the case team that's doing the investigation now. Which, as I said earlier, the investigation should have been done before the indictment. 3, the protocol used during the prior filter review, including search parameters, segregation measures, privilege determinations, and associated logs or correspondence. 4, whether the government intends to search raw returns or only set the already filtered information in the prior review. With the prior review, what they mean is they already had a review of this quarantine evidence with Daniel Richman, where he could assert privilege. We don't know anything about that, but we know there was a review that included him, person 3 from the indictment. 5, and this is the final one, whether non-lawyers will conduct any portion of the filter review. The filter team is comprised, it says right here, according to the government's filing, the filter team is comprised of 2 assistant United States attorneys and their support staff. Who's in the support staff, they want to know. So only with these disclosures can the court determine the legal validity of the proposed searches and assess any proposed filter process consistent with its supervisory role over privilege determinations. So this is the battle in the United States v. Comey right now. The unlawful appointment of Lindsay Halligan, I think, is the kill switch, and that's coming in November sometime. Might get delayed. There's going to be a back and forth about it. Each side's going to file their brief and probably replies and responses, and the judge will rule. And I think Halligan's appointment is going to be ruled unlawful, which will mean right now, that's what I think. Her appointment's going to be ruled unlawful, and she's going to be removed. And it's going to go down just like Alina Habba did, or similar to that. Which means this indictment is it'll nullify this indictment, because it will mean that Halligan didn't have the legal authority, the power to bring this indictment in the first place. But again, I don't think this is about getting Comey. I think it's about unsealing that material that is currently sealed. Find out.